ITV, certainly the best.
The man went out to bring in thugs to come and beat her.
Yeah.
In a situation like that, do you think women would have seen that and still want to speak?
Really, we're talking
That's
about.
what I said.
So
So
that's-
when they bullied her,
Yeah.
if she's not bold enough, she will shut up.
What is your advice for girls out there that are so desperate to be married?
We women, we have to be really intentional about our parenting.
If you know a child is being abused, or you see signs, a bruise or a child, it has to be investigated.
People barely even breathe when they are going for a shrebi and something.
Party.
You have to be
They can't
smart.
sit
If
down.
you see where they are dressing them up or dragging on both sides, you cannot you cannot breathe.
That's what
And these
matters.
women would stay in those events for hours just to keep up with that beauty trend.
Is that healthy?
That's not healthy.
I am Patricia Uremu Gabriels and we're reaching you live from our Lagos Network studio. Of course, Women in Conversation is a program designed for women to discuss about themselves.
Christmas and a prosperous New Year from Independent Television and Radio.
It's Law and You, the program that brings legal issues to the people and the people to the law. Today, we shine the spotlight on accountability in governance, a cornerstone of democracy that ensures those entrusted with power do not abuse it or abandon their duties. But what happens when public officials fail to perform? Are citizens helpless observers, or does the law empower them to demand change and seek redress? From petitions and, of course, public interest litigations to recall processes and legal sanctions, this edition explores the legal remedies available to citizens when elected or appointed officials fail in their duties. We will be speaking with legal minds and, of course, rights advocates on what the Constitution says and what the court can do and what you, as a citizen, must know. And don't forget, you stay with us on Law and You as it unfolds the power of the law in the hands of the people. My name is Philip Omawo-Gyukpo. We'll be looking at accountability in governance and, of course, legal remedies, that the citizens can explore. We will also have the opportunity to have the presence of a custodian of the law in the person of Emmanuel Obakolo. Big thanks for always having time to be part of the show.
Good afternoon, Philip. Good afternoon, Nigerians.
All right, let's quickly set the ball rolling. A lot that needs to be done as regards getting it right. We have a system that needs to, work effectively. But first of all, what is accountability in governance? And how does it apply to the citizens demanding this? What importance does it have for citizens to demand this from the government of the day?
Yeah, accountability, as pronounced, is to give records. So accountability in governance is the presentation of records on government's administration to the people and how those records have been properly handled by those in government. That is just accountability. So accountability is to ensure that the people understand and have knowledge on how governance is being carried out on their behalf by those in government.
Okay, but what is the importance? Why should they do that?
Yeah. If you look at governments, from the definition of democracy, it's a government of the people, for the people, and by the people. That is what democracy is. And now government is a machinery of governance. So those who are in government, they are managing the wealth of the nation on behalf of the people. And as such, they must give account of how those resources that are made available by the people on the people, so that the people will now understand and have knowledge properly on how governance is carried out. And this government, the governance must be on the benefit of the people. That is all. That is the singular reason why there must be accountability in governance. You don't go into administrative spree or financial spree on how to just spend public funds without being accountable to it.
Okay, do you see a disconnect in between, as in the aspect of the government functionaries, embarking on the accountability project to make sure that they give account to the people and render their still worship, and again the aspect of the people, those who are being governed, demanding this? Do you see a disconnect?
Yes, I say a disconnect because if you look at the provisions of the Constitution, the extant Constitution of the Federal Republic of Nigeria, which upholds and observe and also demand practice of the separation of power which is spelled out of and enshrined in section 4, 5, and 6, is all about accountability. And also, if you look at section 85, subsection 1 of the extant constitution, we provide for the office of the Auditor General of the Federation. The essence for the office of the Auditor General of the Federation is to provide for accountability, because he is the one who will audit government accounts, he audit government expenditure, and now know how money or monies that belong public fund has been used, administered, or utilized for the benefit of the people. So there is now a disconnection. Why do I say so? Because even the legislative arm, who ought to carry out oversight function in ensuring that the executive, which is vested with the power to perform executive function, and also the runnings of government on behalf of the people, are doing that as spelled out by the law. Unfortunately, we have a legislature, particularly in this Fourth Republic, that is so lackadaisical and a rubber stamp. So wherein instead of them to carry out their function, they are busy carrying out the lullaby of on your mandate we shall stand. That is not the reason why they are elected. That is not why a legislative function. The legislative function is to ensure that accounts and accountability as rendered by the executive are done on behalf of the people, even to them, properly, so that the people can now be beneficiaries of government expenditures and the runnings of government.
Okay, when you say the legislative arm seems to be failing in that, let's draw a dichotomy, because I understand separations of power, by Montesquieu has brought a situation where the legislative arm, make laws, and of course why the executive implement these laws, and then the judiciary, interpret and settle disputes, between all of this. Are you saying generally that the legislative arm under the system we operate in Nigeria is faulty to a point where any elected official seems to be tilting towards the executive?
Yes, and I did say that with specific reference to the current legislative arm of government we have.
Did you say that, or do you say that as regards the officials or the system of practice?
It's not the system, because the Constitution does spell out how...
It's a constitutional provision.
And I also told you about section 85, subsection 1 of the extant Constitution, which also provide for the office of the Auditor General.
So it is not a problem of the law?
It's not a problem of the law. The law is there, is the performance of the law now. And the legislative arm also have what we call oversight function, to question how public funds are being used. But here we are. We have a legislative arm of government with a specific reference to the National Assembly, who approves all manner of laws. And the same National Assembly does not take time to ask questions on how those laws are used for, the performance, how the executive arm of government, how they be able to administer those laws, and how it has been of benefit to the people of Nigeria. There's no question with reference to that. And that is why you see that it appears that there is no accountability to the people of Nigeria. And that is one of the weak point, pitfalls of this administration that we have just now.
Okay. But what do you see as a causative factor? Because everything seems to be placed on a vote. The ayes have it, or the nay.
With specific reference to public funds, it is more than the question of the aye or the nay have it. It is more than that. And that is why I repeat, I did say that the legislative arm has a duty of oversight function, because the people cannot gather like a Portuguese assembly to begin to ask questions on what their monies are used for. It is their representative, both the Senate and the House of Representatives now, at the federal level, and the state houses of assembly at the state level and the legislative arm of government at the local government level, who carry out this functionality on behalf of the people. And here we are. Their performance is abysmal. It's a near zero. Abysmal. That is the right word to use. And that is why you see today that even government after government, there is no form of accountability. And there is no how the people could ask questions. However, the Freedom of Information Act has provided another leeway for individuals or group of individuals to ask questions.
Thank you very much. Well, in case you're just coming across this program, it's Law and You, and we are all about accountability in governance and seeing what legal remedies are available for the citizens to, find a way to put a task on the public officials, demanding accountability, of course, stewardship on the public office. And I've been speaking with Emmanuel Ogbakpolo. Well, Emmanuel Ogbakpolo raised some very, very vital issue as regards, finding a lasting solution to this. It was on my mind. You made mention of the fact that the people are giving their powers to the Legislative Assembly, their representatives, for instance. And then you also did not fail to say that even when or if these representatives fail to carry out the functions stricto sensu as they demand or request, then they also have another avenue to, explore, which is the Freedom of Information Act. Now, how can they do that? Can you deploy how this mechanism works?
Yeah. Section 3 of the Freedom of Information Act does make provision for an applicant, is a citizen now, can make application to any government institution to ask questions or to get information from that institution with respect to the day-to-day runnings of government, even where it is strictly financial.
Exactly.
Now, but that act also provides for exemptions. The act provides for exemptions where a citizen may not have the right, or an applicant, stricto sensu, may not have the right to ask for informations. And note, what are those? What is these exemptions? Exemptions are provided for in section 11, 12, 13, 14, 15, 16, 17, and 19 of the Freedom of Information Act. Section 12 specifically provides for defense, that you cannot come and make inquiry or get information with respect to defense. And I think that is commonsensical. That is understood. But where it has to do with accountability on how government is being run, with special reference or specific reference to public fund, that information must be made available to that citizen. And where the act again goes further to say where that is refused, that applicant or that citizen has a remedy. Well, section 25, it cannot make an application to court for court to grant order to get that information.
We'll get there, gradually we'll get there. But let's explore what you just said. You have a way of troubling my mind. And of course, I don't know if you're also doing same ripples to the minds of the viewers. A situation where we look at it where an electoral act is specifically, establishes the provisions as regards any concept or how a thing should be done, in terms of accountability. And then there's still another way in which such a person or citizen cannot, explore, in details or directly or, totally from that same, function. It seems to my mind that it's an attempt to kill an initiative ahead of the purpose. I don't know how you explain that.
Well, the law has a golden eye, and the law sees the past, the present, and the future. That is the position of the law. And I think that is the singular reason why the law makes provision for exemptions. Because
But when you say the law, men work on the laws.
yes,
Before it becomes a law or before they become laws, they were once bills. And so
Yes.
men work on it. So what is the guarantee that the men that work on this do not deliberately work on this in order to, protect their patrimony, their personal aggrandizement that may, they may want to seek from the common good that law or that bill, is seeking for in the law. I don't know if you get me.
yes, you may not, that may not be, that cannot be removed from that fact.
Because we've had this with the Electoral Act,
It could be to protect.
where the Electoral Act, some part, anyways, I'm not to speak on it, seems to protect those who are even the political actors.
Yes, when you make reference to electoral acts, you discover that in electoral matters, they are so unique and special to the extent that even the interpretation of the laws in marrying the functionality of the electoral officers and their performance in an election gives a wide protection. What do I mean by that? There are the courts in even interpreting the law with respect to electoral acts may not consider the actors of their functionalities, of their performance, but may consider what is known as public interest or public safety. That again, to some of us, we may question that what do we mean by public safety, where there is an infringement on the rights of the voter or the electorate. Where the right of the voter or the electorate is infringed upon, is violated, do you not say that whatever interpretation you give is for public safety? That is another question begging for answer. That even the courts have not been able to give answer to. But however, we've witnessed a lot of abracadabra, legal abracadabra, but with special reference or specific reference, to my mind, to the last 2023 general elections. We've seen it. Before now, we've seen that the court visit the law strictly on electoral matters. But just now, we've seen how there is protection with respect to that. But again, let's look at the subject matter. I did say that the Freedom of Information Act provides for exemptions. And those exemptions are specified in sections 11 to section 19, with the removal of section 18 of the Freedom of Information Act. And that you can go to court as a remedy, section 25. Now, you can see that even that law, the Freedom of Information Act rather, also has given the court responsibility to make order with reference to information as applied by an applicant or a citizen of the Federal Republic of Nigeria. So, it's still within the wisdom of the court to so grant or to refuse. Again, we may have the challenge of interpretation in the nearest future.
Thank you very much. But you just raised an issue that needs to be explained in total, because there's this aspect of, getting allocations that the federal government has given to each state, for instance, in their monthly revenues, of course, monthly allocations from the federal government to the states. We've always seen it where it is not properly broken down. We can hardly, have, reports on the monthly, allocations that each state gets from the federal government. All we can get from the Federal Accounts Allocation Committee most times are usually the total amount, that is being disbursed from the federal government to the states. But not the specific amount that each state gets month in, month out from the federal government. And that what you have to get it from the Accountant General of the state to have a well-explained copy or copies of how the state gets month in, month out allocations from the federal government. Should it be so?
Yes, it ought not to be so, because we have seen that with specific reference to the way the executive carry out the day-to-day runnings of administration in this country, it has shown that there is no transparency. In a climate where there is transparency, there ought to be a breakdown. Even the Constitution makes it clear for there to be a breakdown of how public funds are distributed or shared amongst the federal government and the 36 states of the federation. But here we are, some executive maneuverings are being carried out so that the people of Nigeria will not know that. And now, if the people of Nigeria do not have access to that information, what about their representative at the legislative angle of it?
Do they have access?
Do they have access? If they don't, do they ask questions with respect to that, or they are engaged in frivolities? So that is why the freedom, I think, that the Freedom of Information Act now makes provision.
That's the importance.
For individuals, citizens, group of citizens, to make application.
Yeah, because it's
get that information.
Yeah, because it's not every information that will be on the public space.
Yes.
So, but that Freedom of Information Act can also help.
Yes.
If you seek or require such information that may not readily be on the public space, so that you can easily access such,
Yeah,
okay.
position.
Okay, but how fluid or how accessible is the office of the Attorney General, for instance?
It's accessible. It's a public office. You can make your application.
Okay.
And the Freedom of Information Act also saw the possibility of the institution wherein that application is made to refuses to grant that application or request as made. And the Act now provides for, in section 25, that you can go to court to seek a redress so that the court can grant an order. And once the court grants an order, you bring that order to them so that they can furnish you with whatever information as specified in your application.
All right, this is quite a sensitive topic, and we will not be able to exhaust it in one episode. But in the next episode, we're going to be looking more into the sanctions, or how the citizens can be able to access remedies, these legal remedies, in tackling or finding way where the provisions of the law can make sanctions on non-performing public officials that are found wanting in terms of not being able to satisfy the public or the citizens in respect of giving account of their state worship. And that will be done basically next week. But before we round off on this, let's look at the aspect of the legislative arm, for instance, that you raised. This is an important arm of government that helps to oversee, deploy, that helps to look into oversight functions of the executive. Now, how can we strengthen this body in order to be able to help in accountability of the executive?
The law is clear with reference to legislative oversight, and that the legislature, their function as provided for by the Constitution is not just to make laws. Like we have agreed, they also have oversight functions to perform.
Yes.
And when they refuse,
but they are lagging in that aspect. Like what you said, they are lagging in that aspect.
Yes.
So how do we strengthen that arm? But first of all, what could be the causative factor, and how can we strengthen that arm for it to be found, living up to expectation?
With the kind of legislative representative we have, and the unique structure of Nigeria, democratically, legally, and otherwise, we may have just one function, or one role to play, and that is where you discover now to the citizens, where the citizens of Nigeria discover that the members of the legislative arm of government are not carrying out their functions as legislative arm. In the next election, don't vote for them.
Okay, you are talking about, okay, before that, we could also, explore the aspect of the recall process. And of course, sanctions that may also be given on that. But well, that would be what we will be having same time next week on Law and You. Well, big thanks for taking our time to be part of this. Basically, that's what we're going to be looking at in the next episode, because we want to look at the recall process. How is it done? And of course, sanctions that will be given on non-performing public officials. How would that be carried out? So big thanks for taking our time to be part of this.
It's a pleasure to me.
My name is Philip Omar Gripo. We'll see you same time next week. Bye for now.
Merry Christmas and a prosperous New Year from Independent Television and Radio.